Hello, ladies and gentlemen. Welcome back to the SAPI IP Business Talks. Today we have a very specific topic. We talk about quantum technology patent portfolios. That's quite a tricky issue, and I'm very happy that we had so many registrations. We will talk about that today with Dr. Urs Ferber, partner at Newman Ellis. And just before we start, I would like to give you some housekeeping information. So we are live on LinkedIn, which means we are happy when you write your comments, your questions to us, to the discussion, to us in the chat, and I will pick that up and then can discuss also your contribution. Urs is a long-standing IP expert. Urs, my first question to you, so I have here your CV or some aspects of your CV which are very relevant for our today talk, was how did you came into this, let's say a little bit exotic field of quantum technology and IP?
Hi, Alex. Thank you for having me. It's a great pleasure to be here. So what we saw at Newman Ellis is that quantum is a very growing market, and we obviously wanted to tap into this market. So that's why we set up our quantum team. And I, having my physics background and working with some quantum startups, was already working with quantum startups. So I was joining the team, and then over the years the team grew. So I'm leading this team, and that's how I came into that. It's just it's an exciting technology. It's a growing market, so we thought it might be foolish not to engage with that market and be prepared for the growth of the market. So we deliberately hired team members or new attorneys or trainees that have a specific background in quantum computing or other quantum areas, just to have our team ready when the clients come and ask us quantum-related questions or quantum-related help.
Yeah, very fascinating, because I had a discussion with the announcement of our talk. One of our ambassadors at the IP Business Academy is Maya Fenster from Israel, and he wrote a comment and said, what do you mean with market in general here in this case? And then I think it's interesting that when we talk with IP experts, it's again and again a tricky issue, the terminology of market, because basically we have two markets here. We have the market of the technology per se, which is an investment object and research object and so on. And of course, we have a market for IP support, because at the end, these users of the IP system, they need support. And this is again a market because there is a demand and there are suppliers for that kind of support and demand, and that creates a market. And the scarce resource is always the IP knowledge in this technology market. And insofar, I'm absolutely happy, and that's why we invited you, because your communication and from your praxis group is really relevant for the users of the IP system. And so thank you very much for joining us today. And we are also very happy to have our expert contributors, Lukas Brunkhorst, Angelika Hutterer, Burkhard Scharfenberger, Eric Fischer, Adrian Steffens, and Ed Kavanagh. Thank you very much for joining us today and discussing with us these fascinating topic. So when we want to approach the topic in general, I would say, and we want to talk about these portfolio issues, right? So not what is patentable in general, it is much more how to design, how to maintain a portfolio. And at the moment, we have a very fluid situation. James Utterberg explained that we are in the very classical fluid situation. Jack Lutherberg is famous for his dominant design theory. So in the beginning of a technology, you have very different kinds of approaches, like in the computer industry, for bicycles, for typewriters, for cars. In the early times, you have a lot of different approaches. What today we don't know what a quantum device will be, what a quantum computer will looks like. It's not clear what the dominant design is. So these architectures, the applications, that is all still emerging at the moment. And that raises obviously the question how companies, so users of the IP system, startups, but also companies which simply apply the technologies. So how should they decide which innovative approaches, which innovations in general might be strategically and or commercially important, that they should go in the direction of a patent protection. And I think here, especially the difference between strategic and economically or direct commercially is also relevant. So what is your perspective on that? Is there a guideline? Is there a kind of checklist? What do you think?
I know, especially when I talk to startups, I always emphasize that a patent is a commercial asset. And for everything you do in relation to patent, you need to have this return in investment. So you invest a lot of money in filing a patent, prosecuting a patent, at the end maybe paying maintenance fee. And obviously this is an investment, and you always need to check whether you get as much as return as well or more. It's a commercial sensible decision to do that. And if you have that in mind, I think the decision when to file a patent, how to file a patent comes a bit clearer, because then you need to look at the commercial roadmap or business ambition the startup or the company has, because then you can align your patent strategy with the commercial interests of that company. So although, as you said, we don't know what the quantum computer will look like in the future, this is very fluid, but I think every company, every startup has this roadmap, this business, what they want to do next, what are the milestones in the next 2 or 3 years. And if you look at that, then you can see whether filing just a patent application for this aspect aligns with your commercial strategy. And only if it aligns with the commercial strategy, I think it makes sense to file or consider filing a patent application. Obviously, a lot of other factors in play as well. But if you look, you have your commercial strategy, then you can at least avoid this, or don't have to look at what your fluid target is, where your quantum computer might be in the future, but you can more or less align your patent strategy with your own commercial strategy. And then you can decide, for example, what you want to file right now, whether it's actually the patent or the technology you want to protect is in alignment with your strategy. Is it just something nice to have, but really doesn't benefit you as much, and so on? You can have all of these discussions. So I think, for example, for startups, they often have a core concept. They're often deep tech spin-outs from universities. There's some underlying concept, and obviously that might be a useful starting point for filing your first couple of applications, namely you want to protect this. And that obviously needs to be aligned with your strategy. And then you have these second considerations. Might that be covered variations of your strategy, because you don't know what you might be doing in 2 or 3 years' time.
Yeah. Let me jump here, because
yeah.
I mean, don't get me wrong, but this is a very generic logic. It should be aligned with your strategy. Okay, given that, Meyer Fenster, I mentioned him already, so thank you very much that you are here. Meyer Fenster is an ambassador of the IP Business Academy, a very active partner. Very happy that you are here. And he says, obviously, something very true. It is a whole ecosystem. It is a tech stack. Okay. But that leads me to you said we have this roadmap. Okay. So the question is that just your roadmap? Because I think we agree that a patent is a forbidding right. And the cornerstone is pretty often not so much what you have invented or not, it is what you want to forbid others. And when we think about ecosystems and the question, which positions do you want to, gather, claim for you, then maybe you do not just think about your um, roadmap, you also have to think about the competition. And sometimes when we discuss with quantum companies, then they are so focused on their issues, on their problems, on their technical challenges, that I have sometimes the feeling they forget that a forbidding right has an impact to the others, and that it's I think, or the other way around, do you think that this forbidding character is an important aspect to think about when it comes to portfolio design?
It is obviously one of the main factors because, as you said, it's the essential feature of a patent that you can forbid others to work on your technology. I think this is a key considerations. And as you said, obviously you look at your own strategy, but I see quite a lot that especially startups know their competitors. So that maybe all scientific groups with the spin-offs, so they know what the competitors are doing and they know how what the others are doing, so they can see how this patent or this forbidding right might be useful in that context. But I think we must not forget that a patent has also other indications, or there are other reasons for filing a patent. So it's not just blocking your competitor from you using your own technology. It's often an indication that, for example, if you file a patent application and you get a positive search report, and it's often an indication that no one else is using that technology. And I think this is, especially for investors or funding rounds, very, very important that you can demonstrate you're the only one in the world working on this technology. And so there's virtually no competition. I think this is very appealing for investors. So, as I said, one of the blocking functionality of a patent is there, but you have all these knock-on effects and other effects that the patent filing can provide you. And I think this is equally important because I think it's for many startups, there's a budget problem, there's a funding problem. So you have your investors also in mind when filing a patent, because this is the forbidding right of the patent may not be important that you secure your next funding round. So this is
absolutely. Absolutely, I completely agree. I just would say it is a bit challenging to derive directly from the in a complex technology like quantum. We should be at least very careful with the message to the companies that once you have a patent, you are the only one who is allowed to do that. So freedom to operate and the forbidding potential. So the exclusivity, the given exclusivity, is also, let's say, quite a challenge, right?
It is, and I've spoken to an investor, and they said patent filing is maybe not as important for them compared to the freedom to operate, because they want to know whether they can work in the future in this field, they can sell their products. This is more interesting for them compared to having their own patent rights. I'm not saying you shouldn't file patents, but I think this is worth to keeping that in mind, that freedom to operate is very important for investors, especially for startups. This is obviously very relevant that they are attractive for investors.
Yeah. So Burkhard gives us an interesting point here. Basically, it's about timing. Okay, so he says we don't have a grace period. We have a first to file principle, blah blah blah, and now this forces at the end. This forces the companies to file patents as early as possible, whatever that means. And do you think that this is an incentive structure which is helpful, or what can be, let's say, how should we consult our quantum companies when it comes to this question of timing. So, I mean, we don't want to file in a pre-major status where it is not clear, or should we bypass it with a PCT, or what is your timing thinking when it comes to creating portfolios?
I think the first and most important thing is that you actually consider that. I think once you've done that, then you have passed the very first hurdle, that you actually consider that once it's out there, you cannot essentially patent it once you publish it. But of course, I know it's a tough decision in practice when you file your patent application. I agree that it is sometimes an incentive to file. It's sometimes companies just file something and then wait another year and make a subsequent application and see what's going on. But it's always difficult to find the right moment. And in practice, I think it's also kind of a budgeting problem. So do you have the budget to file this at this current moment? And I think this is just depends very much on the details on the case, whether you might be able to postpone your publication in the scientific sector. You might push things down the line to essentially gather enough or proceed with your development that it's worthwhile filing an application. Sometimes that's just possible, that it just delay the process a bit of the publication. Otherwise, sometimes it's just cannot be done, and then you need to deal with that. And you can have a conversation with the inventors, with the startups, or with the company, what is included in the scientific paper, because sometimes, this is really not uncommon, that the scientific discovery is something else what the commercial aspect of this scientific discovery is. So that the content of the publication and the content of the patent, or the subject matter of the patent, might be different. It's sometimes very helpful. So you focus your publication on the scientific discovery, but your practical implementation of how you can commercialize this scientific is something different, and you might not need to publish that with your scientific paper.
Yeah, and I think that is a very, very important distinction. That one thing is a scientific, other is a technical. And the better we separate these two thoughts, the better is it for a meaningful publication and patent strategy. And I think that's a very important message also to the users of the IP system, that should be that there should be a difference. In addition, I had a wonderful discussion before this the talk here. With an IP expert from Germany, and the position was a bit, there is no funding, there is no further research, too less, whatever. So in our IP expertise demand index, the opposite is the case. And what Ed says is exactly in that, and it goes to this time pressure, okay? Because what we see is that tons of money flows into the field, patent applications go up, need for expertise is there, and Ed says this also creates, and that's why I pick it up, that also creates this urgency of bringing out my own filing, because this is a time pressure, and I know that the others are also filing, and this is a frontier, this is a race, and that creates an enormous pressure to be as soon as possible in the position to get your own rights. I mean, that should be an important part of the portfolio design, that speed is a quality in itself, right?
Yeah, exactly. I completely agree. And I think it's not only for patent filing, it's the whole commercial activity. I think in the startup scene, speed is of essence, and you need to be very fast, and you need to be very ambitious and move forward your production line, because the competition doesn't sleep. And then, so yeah, it is of essence that you are very fast and file early and keep the company moving, essentially. Yes, yeah, I completely agree. And what we see in this case, that essentially state funding, this might be too slow for that. I have heard several voices that state funding, public funding is just too slow to keep up with that rate, that the barriers are too high, and once the funding is granted, it takes half a year. That's ages in this environment. So
absolutely,
speed is of essence, and sometimes you see that the public funding and the other funding incentives don't keep up, and this is a real problem. We see.
And at the same time, we work a lot with institutional innovation system stakeholders, and we hear again and again that the policy is that they want to see patent activities, but obviously that had to be financed, and that is something where we really try to bring that perspectives together, because the companies need the funding also for IP, and especially for IP, because when they don't have that, they have nothing. So that's obviously. So on the one side, the institutional financing support wants to see a reasonable IP strategy, but at the same time they have to finance that also. So Natalie Nipp has a very interesting question, which comes along with something what Udo Gennari already asked, and what is also on my list on questions about for you, because I wanted to ask you what a commercially relevant patent portfolio looks like. And we have different questions about that in the chat. And one is from Natalie. She says that, is there a difference between, the kind of business models which at the end are intended, which has a lot to do with your recommendation that you said it should be aligned with the business strategy. So let us assume the company has already won, which is based on such a business model thought. And this is aligned with what Udo Gennari asked. He asked, what is with licensing? So is that already a relevant issue? So do the companies think about that? And the Natalie spin is more, does that has a consequence for the portfolio? So what do you say about that?
Obviously, when I said earlier, the patent strategy need to be aligned with the commercial roadmap or the business plan, and I think what the difference are, I think with it's not particularly special to quantum, but obviously if you're more on the hardware side of things, I think one aspect of the filing strategy is where you obtain patent protection. So I think with hardware, you can focus on development sides, competitors, and stuff like that. If you're more on the service side of things, then obviously you have probably need more broader patent protection, because your customers can be resident somewhere in many other countries other than just the pure manufacturers. I think is one point. I think another point is also it's easy to prove an infringement if you have a product at hand and you just look at the product, see whether the patented technology is implemented or not. I think it's different in terms of if it's more algorithm related, program related, service related. Sometimes you don't see, or it's very difficult to access a computer code or a computer program, and it's very difficult to prove infringement. So this obviously has knock-on effects on whether you want to file a patent or you can just keep it as know-how, because it will be very difficult to prove infringement, and sometimes you just want to keep that secret, so you don't want to publish that with your patent application how this particular algorithm works. For competitors, it's very difficult to copy that just because it's so difficult to access. So I think this is also a difference in terms of the filing strategy of what you actually want to protect and where you want to protect. Two main considerations.
So that means it makes a difference, and the clearer it is, the better, which leads me to the next question, and this is the point that obviously these companies have to be as flexible as possible, because we are in the fluid phase of the whole technology. We don't have the dominant designs for the different, let's call it, products. which we will see in the future, and that leads to an issue to keep how to keep the portfolios aligned with the developments out there, and that is also a question from I think from Luke. Let me check. Yeah, from Ed. Ed asked a very interesting thing here. Are there pros and cons? So I would say, is it different when you think about a government or anyhow public funding, or you have a private investment in terms of IP? And that is also a question of how to. So you have funding rounds. So there is no one and only funding. Typically, you have funding rounds, and you can have very different investors in it. Quite often, you have both public and private, and you have this flexible, this dynamic development of the field. So first, what Ed asked, is there a difference? Can we as IP experts help there? And the other question is, how can we adapt? How can we align continuously our portfolios with, for example, financing priorities?
I think you raise a very important topic, that you continuously do that. I think that's something. It's not just you decide once and then you have your strategy set in stone. I think you need to have a continuous conversation with your company, your clients, on your patent strategy. Will it continue to align with your strategic roadmap? I think there are from what I see, there are different aspects of pros and cons with regard to public funding and private funding. I think especially in the early stages, public funding are more easily accessible, and startups can secure these, I think, easier in a sense that they have more flexibility in what they want to develop, and they're just going to essentially starting, say, these pre-seed rounds are often state funded. Later on, we often see private investment, and what we also see in Europe, especially in Europe, there's a gap between those things. So we have a lot of good private funding for early stage, but then there's less of investment funding. I think it's closing a bit, and compared to the US, we have a lot of private investment early days on. In terms of strategy, I think my experience is that private investors have a more keen eye on the patent strategy, because they're very much interested in the roadmap, the commercial roadmap of the startups. So, and obviously this commercial roadmap should ideally be supported by the IP strategy. So they often look quite closely on what is the IP strategy, does that align? Is there a strategy? Is there alignment with the business plan? So that's a difference. What Ed said, pros and cons. I think there are obviously pros in terms of when your private investor urges you to have a strategy and work to that strategy and work to your business plan. I think that sharpens your mind. And another pro is that what we discussed earlier on, that these fundings are often faster. So to keep up that race, to be in the race, I think private investment is often helpful in that it's just faster, and you can keep up in terms of public funding.
Okay, got you. There is another question which has to do with the portfolio design, portfolio maintenance, which is a very generic question, but I think Johannes says that there is this, and this is a general discussion in all technologies, but let's focus here on quantum. And we have this. So first of all, do we have it all? So let me ask the question a bit different, okay? First of all, I don't think that there is a trade secret versus patent issue. Okay, I don't think that it makes sense to think about that in this way. We have know-how aspects which for commercial reasons, there are good reasons to keep them as a trade secret. And depending on the strategy, that can make sense. And we have other aspects which are absolutely have to be a forbidding right and to be public to third parties, which have to be a patent. So I don't think that this versus makes really sense. So let's cover this issue a bit different. So what is your experience and recommendation when you work with users of the IP system in the quantum technology? How do you deal with these trade secret and patent aspects? So, because trade secrets has a lot to do with training, with organizational implementation. Is that something which you recommend and you deal with, or is it more okay? What you can patent, you should patent. So how do you tackle that?
I think, just going one step back, I think the first thing is that you need to realize, or the startups need to realize, what is actually your trade secret or your know-how on what you want to patent. I think that often is lost in the development process. That there's a lot of going on and nobody really looks at what is actually something that you can patent. I think uncovering this or looking at that, what might be something you can protect, that's the first step. And then the second step is obviously, is it actually worth protecting that? Is it something we can enforce in when we get out there, or is it actually something we want to keep secret because that's of more value to us than having it published and publicly potentially enforcing it? I think there are many factors to consider. It's not only the fact whether it's better be a secret, it's also against whom you might want to enforce that patent. It's just, if the other company, your competitor, has just the deeper pockets, and you probably will never start any infringement proceedings, then, well, maybe it's better just to keep that secret. And because even if they do infringe that at some point, you're never going to enforce it. So I think these are just these multifaceted considerations. And again, I'm repeating myself, but I think it's just so important. It's having these conversations that are the most important thing. Once you have and you come to a decision, then it's absolutely fine. If there's no patent or a trade secret, that's I think at the point. I think you're having these discussions, but then you make a conscious decision either to file or not to file. And I think this is, in my experience, this is something that just gets not done because it's speed is of essence, so that sometimes just on the back end, and then it's sometimes too late. But having this continuous conversation with our clients, that's the important bit, that we are engaged in their development process, see what they want to do, and then we can interact and advise them and frame the right questions for them to consider. I saw that you developed that. Do you think there's something we could patent in the future, or have you thought about that? I think these are the essential questions. I don't know. Everything else is just a follow-on that is very specific to the case and a lot to consider. But I think the essential point I really want to bring it across is posing these questions, thinking about that.
Yeah, that leads me to a very important point. Sorry?
No, sorry.
Yeah. That leads me to a very important point, because in many, let's say, established companies, product-oriented companies, we see there are many studies about that. So it's not just empirical evidence. It's not just my own experience-based evidence. That IP is often a kind of afterthought. So we made this development, we made this innovation, and then, there is maybe an invention in it, so should we patent it or not? I don't know. So obviously what you say is that we need a very strong alignment in in quantum technology, we need a very strong alignment between the development and IP, and this is a continuous process, and obviously not an afterthought. And this brings me to the question that let us assume a quantum company is entering, so they have the idea, they have maybe a further investments, or what Angelika said, that also investors are often enthusiastic for a technology, for an application field. So they give you the money to go in, and then what do you think about, freedom to operate, competition, third-party rights, and also, so how does that influence, or should that influence also business and R&D decisions? I mean, I think the separation of that doesn't make any sense, because you can have all the money in the world when you have an IP situation which you cannot win. The question is, why should you go in? So what do you think? How should this IP thoughts influence R&D and business decisions in such a situation?
From what I see, it does influence the business decisions, because as earlier on, investors are quite keen to have this freedom to operate. I think that's the first step. And then the second step is obviously to look whether you can rights out there that potentially you infringe with the product. And in many instances, especially in the early stages, there are design arounds. And sometimes it's not even clear which route you want to follow. And then obviously if some of the routes are blocked, then you just focus on a different route. That's something we see, or I have seen quite a lot in the past, that they want to just change that. And with obviously, and then I think one further thing is then what you said, if there are existing rights, then licensing and how to collaborate maybe with the patent holder in these areas, or licensing this technology is quite something the startups will consider. And sometimes it's even a starting point that the startups consider actually not developing this technology on their own, but just implementing this technology, or using the competitor's technology for their product, if that's just one building block of their own product. So there's sometimes it's just an incentive not to do that on your own, but just reach out and see how you can collaborate with these other companies, and then just implement it. And it's even sometimes it's a shortcut to your product, because then you have solved one problem. So in general, I think freedom of operation is very important. It gives you an idea of what you can do, what you will do. That's the main purpose, but it has also these knock-on effects that you can actually shape your business strategy with that in mind.
Yeah. I mean, that is this is easy to say, and a big challenge when you say that IP should shape the business strategy. But I can't agree more. Nothing else makes sense here.
Yeah.
And it is a very important message to the users of the IP system who are listening here, to the startups, to the scale-ups, also to institutional representatives. We an IP as an afterthought for when somebody typically has no clue about IP law might think that something is invented. I mean, and then they want to have a patent or not. So this is a kind of thinking which is absolutely not helpful. And what you said is FTO. So I think Udo said that here, Udo Chinari, that there are so many. So there's a flood of academic or in general papers out there. So that these not just patent literature, so especially also the non-patent literature is extremely important in that field, because not everybody is separating the technical implementation from the scientific research publication. And Eric Fischer mentioned here, and I think that's just a comment, but I think it's important that he said, especially startups or scale-ups have to be very careful about trade secrets, simply because they have a certain change, and many people and interns and whatever come into that company. So that's not a bug, that's a feature, that these companies are populated by guests, by research partners, and so on. And that a trade secret strategy can be very, very tricky and maybe even dangerous when it's not handled in a way that it should be. And this is even for bigger companies a very challenging aspect. So one thing which puzzles me, that is we are right now, we made this quantum in motion post, and we published a lot, and at the moment we have also a market study about that, and our impression is that we have now a very specific situation in the market for quantum technologies, and as I said, also for the IP of quantum technology, that we have now the prototypes come into field trials. We see also that the real big companies like Microsoft, like Google, and so on, they come up with their solutions with heavy patent portfolios. And we see now customer demonstrations. We see that more and more the quantum solutions, or what is seen as a solution, is come to a market, to public. And of course, confidentiality doesn't work anymore here. So when you go out, what can IP do? What can IP experts? How can you help to avoid the feeling from the companies that IP is slowing them down? So how can in commercialization? So how can IP even help them to with the commercialization and with keeping pace and speed in that enormous, under this pressure of this race and competition?
I think the first thing is we need to keep up with the speed as well. So I think it's one important point, that it's not like, oh, we could take ages of time. I think we need to be as fast as the startups and as fast as this environment is growing. This not only means delivering the word product, but also keeping up what's going on out there. So we need to stay informed, stay in touch with the community to know what's going on. And to your point about how we can help that, I think this is when we, as a patent attorneys, or I'd like to think of myself as an IP advisor, are engaged in the field and know what's going on, we can help them make their IP strategy or decide on that, as we asking the right questions, as long as we are involved in the process. And I think so we can help them with their IP strategy and advise them on what's going on. I think that accelerates the process quite a lot. And to be honest, I enjoy more doing that work than actually writing a patent application, because I know that I get a bigger picture of what's going on in the company, what they want to achieve. And this is so fascinating for me to see what's going on. And once we are engaged in this process, I think the process becomes way faster, way more focused on what needs to be delivered, where's the commercial angle of everything, and each patent filing or each new invention. I think these discussions will speed up the more the patent attorney is involved in this process. And I think at the end, this makes the whole process more efficient and much faster. And so in that regard, it shapes the IP strategy.
Yeah, so I would like to summarize their thoughts. Yeah. Because again, I think big thoughts, very, very calm spoken by you. First of all, it's the will to understand the business, is the will to understand the commercialization, and not reducing the thing to the invention per se. I think that is very, very important to get into these commercialization thoughts and really to ask about that, the will to understand it. The second is that the communication. I mean, you are here because we think that Björn Ellis, and you especially, make such a very good communication in the direction to these companies and to these users of the IP system. And many others sit there and just say, okay, I'm a physicist. I also understand what something from quantum, you can come to me. I mean, this is obviously not what this target group needs. And finally, these alignment, this speed, this is an attitude. Yeah, so it's not that will take time. No, it's we are your partner and we want to be aligned and we really want to be with you on this race. And I think that together creates that kind of partnership, which is absolutely crucial in that field. Okay, I think thank you so much. Unfortunately, I was really not able to pick up all these very, very good questions and comments. Robert, yes, I saw your standardization issue. Maybe we make a dedicated interview about standardization and quantum and IP. That is really a topic which drives us around. And what I want to communicate, there is a lot of already existing content available on our industry focus, free of charge. Even a complete market study is there, which we published some weeks ago. And you are, of course, invited. We right now plan a new open foresight board fireside chat. So you see the two places, the two seats are empty at the moment. So we organize a fireside chat. This format comes from the Open Foresight Board, where our industry representatives are organized, and we invite users of the IP system, 3-4 guys who are interested in a very specific topic, and we invite then IP experts who are willing to answer to this kind of specific discussion. Obviously not public, but when everybody agrees, we report what we did there. And next week, this is a coincidence, we talk again on quantum together with Ed. Ed is today here. Thank you very much for joining us, and his colleague Daniel Speeds. So that was the live talk for today. Urs, thank you so much for taking the time, and please stay with us in the after show party on LinkedIn. We try to answer all your questions and give you additional links wherever it's necessary and wherever it can help you.
Thank you so much for having me. It was great fun. Hope to do it again.
Thank you so much. Bye-bye.
Bye-bye.